I'll now give the floor to Grégor Puppinck, who is Director of the European Centre for Law and Justice in Strasbourg, and he wants to explain why abortion is not a human right and how to prevent it. So, Dr. Puppinck, you have the floor for 8 minutes.
Thank you very much. Thank you. And you're welcome. And also I'd like to thank you, Madame, for inviting me to come along to speak here on this very important subject. It's quite rare for us to be invited to talk about our pro-life battle in this Parliament, so thank you all the more for that. Yes, indeed, abortion, unlike what we might believe or what we hear in places like this European Parliament, is not a human right in the strict sense. I'm not going to show this. I'm going to have to prove this, because everyone knows this. Even those who promote abortion know that it's not a human right. I just wanted to remind you of this and be able to illustrate it with 5 or 6 points today. Firstly, you've got to remember that the child who's going to be born is not necessarily excluded from any protection under human rights legislation. So indeed, there is a legal basis for that. Secondly, abortion cannot be seen as a right or because the child that is going to be born does exist already. So you can have a right for yourself, but you can't have a right over someone else's rights. Thirdly, abortion can be seen as a derogation or an exemption to the right of life when the life of the mother is in danger. Fourthly, abortion, which is sometimes said to be à la carte, cannot therefore be a human right if it is selective. Fifthly, some cases of abortion which are carried out because of the health of the mother are called eugenic abortions, and which are being called into question today in law. Sixthly, what can we do in this situation? Abortion is not a right. It's practiced in most countries in Europe. So rather than promoting a legislation which would protect the child, countries do have to prevent, I think, access to abortion. Firstly, as I said, the child to be born is not excluded from human rights. The child which is going to be born, which might be called a fetus, an embryo, is actually already in existence, as the European Court of Justice has said. It's not something which is simply a future in the future. It's something which already exists. The European Court has already recognized the fact, and this is important, that the child to be born is not excluded from the coverage by the Convention, simply because the Convention doesn't state this. It doesn't state where the limits of the right to life actually begin. The courts in the judges in the European courts have said that therefore countries can decide to consider the child which is yet to be born as a full person, and can therefore have its right protected. Therefore, indeed, the European Court has already accepted that they could accept requests or applications on the right to abortion under Article 2 on the right to life, and 3 right to protection from torture, and the protection of family life. So the fact that the court itself has actually agreed on the admissibility of applications on the validity of rights of the child to be born shows very clearly that the Convention should be applicable to human life before birth itself. So the Convention can be seen to be applicable to human life before birth. There is no a priori exclusion. Secondly, abortion cannot be a right or a freedom, because its aim is the existence of someone else. Now, the fact, if it was a right, if it was a freedom, it would mean that you were allowed to annihilate an embryo or a fetus. So you can only have this right if the embryo or the fetus amount to nothing, which is why it's important to discuss the status of the embryo. Now, as the European Court has said and has admitted that the fetus or the embryo is already a living life which belongs to the human race, it's therefore impossible for abortion to be a right or a freedom. It's clearly necessarily something other than that. Either it's a violation of law or it's a derogation to the general legislation. Thirdly, legislation can at most be a derogation to the right to life of the child. As all exemptions in law, a derogation or exemption must actually be aiming at the same principle as the one on which it's based. So an exemption to the right to respect life must actually have the finality of respecting life, which is the reason why an exemption is only possible in the case of respecting the right to life of the mother. And all states do allow for abortion when the life of the mother is in danger.
Par extension, certains...
Now, by extension of this right, some member states, or some states rather, have permitted abortion when the life of the child is under threat because of the circumstances of conception, when the child was conceived following rape or incest. So it's also by looking at the circumstances of conception and the impact that this might have upon the mother, the risk of suicide, for example, that in certain cases abortion would be permitted. However, this is an exemption to the law and does not provide a right to abortion. Fourthly, abortion à la carte or on demand is not a right of human right. We have already seen that all of these, all legislation is looking at the only abortion which would be permissible would be if it was to protect the woman's life, the mother's life. The right to life is an absolute right. There is no exception except for in case of war. So there's limited cases in which a woman's life actually takes priority over a child's life, but it's very clearly stated in the European Court of Justice that the convention which guarantees the right of respect to life and self-autonomy says that it cannot be interpreted as installing a right to abortion. The United Nations have never said that states have got to legalize the right to abortion on demand. So, during its settled case law, the European Court has not said that there is any right to have an abortion, to practice abortion, or to have to go abroad for an abortion. It's also judged that the prohibition of abortion is not actually against the law. So then there are abortions which could be argued on the basis of the health of the child. You can see it from two different angles. Either the child is not said to be viable, that the life is not viable. So even if we're going to accompany the life of this child in a humane fashion and support the mother, that is one thing. However, if the child is simply handicapped but still viable, then there is a question of whether we would permit eugenic abortion. Abortion is not being requested because of the health of the mother, but because of the health of the child and because of the consequences of this handicap on the child and society. Such an exemption, an eugenic exemption, has been rejected at the drafting, when there was a drafting of the Universal Charter on Human Rights, because it was very close to the Nazi policy in this area, but we've seen that such a practice is actually current in countries where there is diagnostic tools at prenatal level. Sorry, we've got to conclude soon. So finally, then, the handicapped people are actually rejecting eugenic abortion, and they do feel that this is a discriminatory measure. So the Committee on Handicapped People's Rights in the UN has said that countries where there is this law which allows for abortion in cases of a handicap is actually in violation of the legislation on protecting the life of the handicapped individual. So this is the rights of the handicapped people is given primacy. Thank you very much.